Okay. This bill does not treat a maritime area consent as having being environmental, right? In the same way as development consents. And we're concerned about that. I mean, to give you an example, as I said in relation to our earlier amendment, if you don't have a MAC, you can't do anything. So one thing leads on to another. The government and the officials will say, well, a MAC only gives you the right to occupy, but it is also the first step on the road, without which you can't do anything else that comes afterwards. So we consider it, particularly because we're dealing with legislation where, we're in new territory, and how one thing can lead on to another. We think we're not convinced that the assertion that a MAC doesn't have environmental, impact, if you like, is necessarily going to be the case. And I'm not saying you're being disingenuous or anything in that regard, but just because we are in new territory and we think, we're setting up a process that we don't quite know how it's all going to actually play out. And therefore, potentially MACs will have a significant impact, and that people may wish to challenge the granting of a MAC and take judicial reviews against the granting of MACs. But if they do, they will not get the protection that you would get under our House for things that are deemed to have an environmental impact. Because this bill does not consider the MAC as having an environmental impact. Therefore, you don't get those protections, and you could be screwed, excuse the colloquialism, you could be screwed for costs and discouraged from doing it, whereas our House gives some protection to things that are deemed to have an environmental impact in terms of protection when you take judicial reviews on those grounds. So these amendments that we're putting in are trying to ensure that people are protected against major costs, that when they take judicial proceedings or judicial review, or seek a judicial review, should I say, to use the right language, seek a judicial review against decisions to grant a maritime area consent. Are we dealing with, what amendments are we dealing with?
Dealing with.
Up to, does this include 44? Yes, it does. Includes 44.
42, 44 and 49 to 51.
Trying to keep up with this. Yeah. I'm telling you, it's difficult last count, Corla.
It is.
But important, and that's the problem. A lot to deal with in a very short time. 44, I want to particularly draw attention to, is that where the application for judicial review is a body or organisation whose aims or objectives relate to the protection of environmental protection, namely NGOs and so on, that would have the objectives of protecting our environment and knowledge and expertise in that area, that they should have locus standi, have the right to take judicial reviews, standing to take, and would be deemed to have a sufficient interest, so that there won't be any barriers to such organisations taking or seeking judicial reviews on maritime area consents. So this is, a further attempt to ensure that the granting of MACs does not compromise our environment, our marine environment, and allows those concerned with its protection to challenge decisions to grant maritime area consents. So that's the general thrust of this group of amendments. 51. I'll maybe come back to that in the second round.
This group of amendments seek to amend various judicial review procedures set out in this bill, and I wouldn't state from the outset that I will not be accepting any of these amendments as they've been developed in consultation with the Attorney General's office, and we are happy with them as they stand. To touch on the substance of these amendments, firstly, Amendment 44 seeks to insert a provision providing locus standi for certain cases. There are a number of issues with this amendment, as discussed at length at committee stage. I do not accept that the MAC is an environmental decision for these purposes, and the advice I have supports this position. This amendment seeks to attempt to establish the MAC as an environmental decision by reference to the proposed insertion. It is simply not acceptable. Notwithstanding that, I would have serious concerns with the proposal that a body or organisation could establish itself and pursue environmental objectives for just 1 month before it could have locus standi in judicial review proceedings. This is a significant deviation from the existing provisions, including the existing provisions of the Planning Acts and those proposed in Section 133 of this bill. This provision could unintentionally lead to abuses of the system that would undermine the good work of the existing and long-standing environmental NGOs. There is no justification for it, and it is curious that deputies have not proposed a similar amendment to Section 133 in respect of licences. Amendments 42 and 50 seek to limit damages, but the text is without precedent, is not defined and would deviate from existing provisions, including the Planning Acts. In any event, my advice is that it is not necessary. Amendment 49 attempts to provide a definition that is not necessary. The reference section refers to the preceding section where the definition is provided in subsection 7. Amendment 51 seeks to delete the entirety of Section 134. I note this deletion was also proposed at committee stage and ruled out of order, albeit that it was also proposed at that stage to delete almost the entirety of the JR provisions for licensing. In its current form, it still proposes to remove the environmental cost provision. While I note the justification for this, I have not been advised to remove this section by the Attorney General's office, and I will oppose. We will, of course, keep all judicial review provisions under constant review, having regard to emerging requirements, case law and other amendments elsewhere, such as any future review of the Planning Acts, but I will not be changing them here without specific advice of the AG.
Dr. Boyd Barrett.
Yeah, look, this is all about access to justice and the right of concerned parties, and particularly NGOs who'd have a particular concern about the potential impact of human activity or development in the marine area if consents are given or decisions are made which they think could be detrimental to that part of the marine environment. And so that access to justice is important. Just like I don't really buy the narrative that we often hear, particularly from the developers on land, that the big problem is all these people who object, even though they get multiple planning permissions, and they either do, in many cases, bad development or they don't bother developing at all. So I don't buy that narrative that giving people the right to object, to go to court, is a problem. It's imperative that people, and in matters that have an impact on their environment, in this case the marine environment. I don't see the month issue as a problem. It's about actually facilitating groups of people who may come together in the context of a particular proposed development, because many people, until something is actually proposed, don't know it's coming, may not have organised themselves, but may have very legitimate concerns about it and establish themselves in response to that. So I don't have a problem with that. I don't see the concerns that the Minister the Minister suggests. I think that trying to not have a chilling effect of the potential of costs being unloaded on people who seek justice, particularly when most of the time we're talking about they will be dealing with big corporations, big commercial interests that have plenty of money, plenty of legal wherewithal and so on. So what we're trying to do is ensure that they have that right, that recourse. And as I said, just to conclude, Cian, we don't accept that the maritime area consent may not, even the right to occupy, even if it doesn't actually allow for development, could potentially, we think, maybe have displacement effects on that particular area and therefore have environmental impacts. And so we think that those access to justice provisions and no deterrence to that are legitimate requests on our part, vital indeed.
Okay. Anybody?
Just to reiterate, we don't accept that the MAC is an environmental decision for and again, we can't accept that what this amendment is seeking to propose, that the MAC is an environmental decision. Also, the issue of organisations that might set themselves up just for 1 month, again, we can't accept. I think there are many environmental organisations out there. There are many environmental. Just to say that there are many environmental organisations out there that have been operating for a long time, Friends of the Irish Environment, Friends of the Earth, Coast Watch, Birdwatch, Swan. And again, if organisations have concerns around issues around the maritime area or in general, these organisations are there for support for them. So I think we can't accept this.